This institution is an equal opportunity provider.
Hello, everyone, and welcome back to the 4-H Summer Program podcast. My name is Mitchell-Hawkins, and this is episode 2 of 4 of our podcast series. And I am again here with...
Hey again, my name is Margaret. Todd. I go by Megan. I am a senior legal specialist with the Agriculture Law Education Initiative, or ALEI for short. ALEI is an Empowering the State initiative. We are a partnership of 3 of the University of Maryland campuses. So myself, I'm from the University of Maryland, Baltimore Carey School of Law. I have colleagues at the College Park campus and at the University of Maryland Eastern Shore campus. And our work is really focused on providing legal resources, educational resources for the agricultural community within the state of Maryland, focusing on kind of increasing legal literacy around issues that businesses, farming businesses face pretty frequently just during the course of operating their businesses. So it could be land use and zoning, it could be business formation, estate planning, things like that. So we have a lot of our resources, publications, and videos all for free on our webpage. It's www.umaglaw.org. I encourage everyone to check out our website and see what we have. Hopefully it can be useful to you, helping you understand what some of the legal risks are that are present just by operating your business, and then what are some of the strategies that you can do to manage those risks for your business and kind of get out ahead of them. We are always open to ideas for new resources also. So if you go to our website and you don't find what you're looking for, or you have questions about what we have available or what you've read, you're always welcome to reach out to the general ALEI email, or you can reach out to me directly and provide me your feedback. My email is motodd@law.u, Maryland spelled out, .edu. I also just have to give a quick disclaimer that what we do at ALEI is educational only. We're here to help people understand what the law says. And we always recommend that if you need advice, legal advice or legal representation, which we do not do, but if you need it for your particular circumstances, to seek out an attorney who can help you. And the Maryland State Bar Association does have an agricultural law section that has created a directory just a few years ago now, with a list of the lawyers in that section that often have clients who are farmers or own farm businesses and deal with a lot of the legal issues that farmers face. So it's a great resource to help you find a lawyer for your particular issue or in your particular county or region.
Ms. Todd, we want to thank you for being with us today. And would you like to say what we are going to be talking about?
Yeah, sure. So right now we're going to be talking about digital marketing and advertising.
Digital marketing and advertising. Awesome. So aren't there certain limitations to what can and can't be advertised? For example, like what stops people from claiming their products or are organic or grass-fed when that's not the case?
Oh, that's a great question. And I think it's definitely something, a basic principle that a lot of businesses need to understand, especially if they're taking on that role of doing their own marketing and advertising. They're not hiring a consultant to take care of all that information, all those activities for them. So, yeah, I think the basic. In your question, you talked about what can be advertised, and then some labeled terms like organic or grass-fed. And I think it's important to kind of distinguish that there are a number of laws that apply to advertising generally, but then separate laws that apply to labeling your products with specific qualities. So The first is the baseline, the kind of the blanket that applies to all businesses, whether you're selling food or not, is the Truth in Advertising Law, is what it's named, referred to. And the Federal Trade Commission, or FTC, is the agency that oversees and enforces that law. The basics of truth in advertising are really that it's pretty much like what it sounds like. It prohibits unfair or deceptive advertising in any medium. So if you're doing print ads in a newspaper, you're making flyers to pass out at the farmers market, you have online ads on social media or on your website, or you're doing email campaigns, like any of those types of advertising methods are covered under truth in advertising. And you cannot, when you advertise, you have to tell the truth. You cannot mislead your consumer. And I think that's, yeah, it sounds like common sense, right?
Yeah.
But, I think there can be a lot of pressure to differentiate your product or your business from your competitors. And you want to make it sound like the best there is. And you can do that within reason, right? As long as you're not misleading your consumers. And so it's important to know and understand, like, what qualifies as deceptive or misrepresentation, right? So so if it's deceptive, it can be a misrepresentation, but it could also be something that you're omitting a really important piece of information about your products. That basically, if the consumer knew about that, like, they would make a different choice, or maybe they wouldn't, but they could, right? So it could be something that's false, just an outright lie. It could be something that you say, a falsely disparaging statement. So, you're disparaging a competitor's product unfairly. It could just be kind of misleading. Like, it gives the opportunity for the consumer to draw a different conclusion about your product. So whether it's written in an ad, or if it's an oral statement that you make directly to the consumer, or even in a video, that can be misleading. And the important things to know about this is that, it doesn't have to actually harm the consumer for, if it's misrepresentation or misleading. If that ad just itself is that way, there's no harm to a consumer, but, the Maryland Consumer Protection Division caught on, or if somebody reported you, you can be investigated, right? And you would have to cease that advertising and possibly face some financial fees or fines for violating the act. You don't even necessarily need to have intended to mislead or misrepresent your product in your advertisement to fall afoul of that law. So yeah, it's really important to pay careful attention to the language used in advertisements. This can also be true for marketing or advertising activities. So a lot of times you might think about promotions, things like buy one, get one free, for instance, is something that the FTC also has some guidance around. So, promotions and things like that have to really comply with FTC guidance. In fact, to kind of round out this FTC discussion, I would highly encourage any business, especially small businesses to mid-sized businesses that are just, this whole truth in advertising thing is very murky, and it seems like it's too easy to go afoul, to check out the FTC website, because they actually do have some really good resources specifically for smaller businesses to help them understand what the law means, and gives them some good examples of, what qualifies and what doesn't, on a variety of the topics that we're going to talk about today and in later podcasts too. So that's a great resource for truth in advertising specifically. And then in terms of the second part of your question, falsely advertising their product is organic or grass-fed. So there Those particular labels, organic and grass-fed, those are actually labels that are regulated through the USDA, the U.S. Department of Agriculture, which is really fun when you get to deal with multiple federal agencies, right? Yeah, so like I said, truth in advertising blanket. If you have a food product that you want to label as organic, you're going to have to satisfy those national organic program standards to actually put that organic label on your product. And there are some tiers when it comes to organic, for instance, whether it's 100% organic, partially organic, made with organic material or ingredients. There are guidelines through the USDA that you have to satisfy and apply for to use that term. And USDA would be the one that would enforce that, if you're not using your label. But also, there's another one of joy. The FDA, the Food and Drug Administration, has an act called the Food, Drug, and Cosmetic Act. And that act is, related to food and drugs and cosmetics and prohibits the selling of misbranded foods. And so this is both the federal and there's also a state version of this law. So, even if the federal agency isn't out there enforcing these things, there are state laws. And so the state agencies, correspondingly have jurisdiction to come in and enforce or impose fines if necessary. So misbranded foods is basically selling food that is not appropriately labeled, or it's not safe to consume. So this is sort of just not honed in specifically on the label itself, like organic or grass-fed, but just generally the quality of the food that you're selling, making sure it's safe for consumption. And there are, for people that are in the food production realm, if you've gone through the FDA website, maybe for food safety purposes, you might be familiar with the fact that food items have like a generally a recognized meaning. For instance, a cookie is a cookie, right? And if you're going to call your product a cookie, it kind of has to meet those standards of what a cookie is. And so just making sure your product isn't misbranded. On that level, there are, of course, technical aspects related to misbranding food too on your label in terms of, quantity, ingredients, things like that on a more technical side, not just out of what your food product actually is. So yeah, there are definitely limits.
It sounds like there's so many, but all my mind is thinking about is the concept of state mandated cookies. And I find that extremely funny.
Oh, I want to see that label.
It seems like a lot of the law around agricultural marketing kind of revolves around labeling. And perhaps that's because of the nature of agricultural marketing and selling agriculture and agricultural product. So could you give a bit more information about specific labeling?
Sure, I can try. And yeah, I think that makes sense, right? Labeling, not even just labeling, but just the information that's provided to the consumer. You want to make sure that they understand what it is that they're buying, right? That the consumer has the information at their fingertips to make informed decisions. So from a labeling stance, that's sort of what the consumer protection model is for. And this can be really important for people who have allergies or dietary restrictions, right? They want to make sure that what they're eating or buying to eat for themselves and their families is safe and healthy for them, and also the type of quality food that they want to ingest, right? So that's really the gist behind that. Some specific food label requirements, and this is not advertising necessarily. This is just labeling your product accurately so that consumers know what they're buying, right? I want to differentiate that from advertising, because advertising is different. But for labeling, if you're just selling food, produce, raw agricultural commodities that are going to be consumed either raw or cooked, there's no need for a label for raw fruits and vegetables. The most thing though is if you're selling it at a farmer's market or a farmer's stall or prepackaged, whatever, if you're selling it by weight, it's really important that your label for what the approximate weight is, or actually for what the actual weight is, is accurate. Approximate weights are not okay, right? You are selling it by the pound and you're going to charge them for a pound. So they better be getting a pound of product, right? So for Maryland, there's the weights and measures division, and you have scales that you use when you sell your products, and making sure that you're verifying that your scales are accurate and that your labels are accurate. If you're selling, on the other hand, by a container capacity, like a pint or a half pint dry measure container, that doesn't apply. Or if you're doing it by, the weight requirement doesn't apply in that situation. Or if you're selling your product by like a head of lettuce, like one head of lettuce is $2, then, you don't have to like label it one head of lettuce. I think it's kind of clear in that instance. But for raw fruits and vegetables, very, very low labeling requirements. If, on the other hand, the farmer is creating value-added products, and a value-added product is, when you're taking that raw fruit or vegetable and you're processing it in some way to make it a more valuable product. That's the way you think of it, right? Because you're taking out that middle step of preparation for the consumer so that it's something that they can, have one less step at home to prepare it, or they can eat it directly. So that's how you're adding the value. But for those products, yes, there are minimum labeling requirements. 6 main labeling requirements, regardless of what type of product it is. And that's going to, at minimum, include the name and the address of the producer. So the physical business address. Like if your farm is one place and your home is the other, what the farm address is really, the business address should be what's on the label there. And then in the business name. If you are a cottage food business, or you're doing business out of your house, you can apply with the Maryland Department of Health to get a unique identifier code with them, so that the MDH has your name and home address, but the information you're putting on your label that's being sold to the public is that code, not including your home address, right? So you have that extra layer of privacy there. Second thing on your label for value-added foods has to be a quantity statement. So that's like the net weight. Again, accuracy in the weight of your product. 3, identify the identity of the product. So if it's a chocolate chip cookie, it's a chocolate chip cookie. 4 is the ingredients in descending order of prominence by weight. So, I think we've all seen the backs of labels where they list the ingredients, and usually in cookies, right, flour is the number 1 ingredient. And if there are ingredients within that flour, then you put those in the parentheses following that main ingredient, and then you move on. And so if you have chocolate chip cookies, you write chocolate chips, you're going to put in parentheses then what are the ingredients within that chocolate chip as you carry on down your ingredients list in descending order. If there are any types of artificial colors or flavors or other types of chemical preservatives used in your product, you also have to declare that within your ingredients list. And then not most importantly, but very importantly, contain an allergen warning in your product. So the main allergens are milk, eggs, fish, shellfish, tree nuts, wheat, peanuts, soybeans, and most recently, sesame has been added to the list of main allergens. So if your product contains any of those, you have to have either it clearly is going to be represented within the ingredients list, or you have a separate statement right below your ingredients that says contains and a list of the allergens that are in there. And again, that's just so that the consumer can make those informed decisions about what they're buying for themselves. Yeah, so that's for value added products. If there may be additional label requirements depending on the type of product you're selling. So if you're doing a canned food, there might be additional requirements for having a code on that product. If your product has a shelf life, so it's something that's perishable and it has to be consumed within 3 days for food safety purposes, having that type of information on your label is also required for food safety. Yeah, and there are probably a few others that I can't think about the top of my head right now, but we do actually have ALEI created a resource not too long ago called Regulatory Decision Trees for Value-Added Food Production by Maryland Specialty Crop Growers. And that does have a decision tree type resource for labeling value-added products. And I think that'd be a great resource for people to go through to get more information on that minimum label requirements. And then finally, about kind of more specific labels, like things like organic or local. Those are also regulated terms. You need to define terms. Even if you are a grower who is using organic standards and only organic pesticides and organic seed, everything is organic, you would only be able to use the term organic in advertising your products if you have applied through the USDA's National Organic Program to be approved to use that logo and that term on your product. So, it may very well be the case that you're growing organically, but if you haven't gone through that application process to get approval to use that sort of seal, that organic seal by USDA, you can't legally use it on your product. Similarly, we do have within the state, locally grown, I think is pretty popular nowadays too. People are looking a lot more for local products for just, both for like food system resiliency and just supporting local businesses. And the fresher it is, the better it is. And so Maryland does have a Maryland's Best locally grown branding logo that is something that farmers could advertise either at their farm stand or stall or directly on their packages if they go in and register with the state. And that's marylandsbest.maryland.gov. It's not a whole lot of strict standards to sign up for that list. You just have to be local and be able to prove that. And then you can start using that logo as well. Yeah, so that's some of the information legally around labeling the food product themselves.
Awesome. So it seems like, okay, so if we go back to marketing from labeling, switch back, do the laws that you mentioned earlier regarding marketing also apply to emails, or is that a different realm?
So yes, they apply, but there is also another law specifically for email communications or email advertisements of a commercial nature. And that one is, so like I said, the truth in advertising law, it applies like regardless of the method of advertising that you're using. Just tell the truth. Don't be misleading. Don't misrepresent your products or your business, right? If one of your primary modes of advertising is through email campaigns, like maybe you have a newsletter or a listserv of clients, or customers that have visited your farm stand in the past, and you want to let them know about a new product you have. you started making it like a really great jalapeno jelly. And you're like, hey guys, I think this is fabulous and you want to try it out because you came here before. You can do that, but some of the limitations on commercial emails, are provided again through the FTC and the Federal Trade Commission's CAN Spam Act. That is an acronym. It does not mean that it's only limited to email communications that are like in bulk, or like you're digging them like 5 times an hour, like spamming their inbox. No, it's like it sets rules for commercial emails, commercial messages. That's it. So even if it's business to consumer, it applies. If it's business to business, even it can apply. If you're like informing another business about a product that you're selling, then it has to comply with the rules with the CAN Spam Act. So some of the limitations here that are important to keep in mind is that, yes, it prohibits false or misleading information, just like the truth in advertising law. But there's also a few extra things to keep in mind. So, just logistically thinking, when you send that email message, the from field, so where is that email coming from? That has to be, the actual email of the business or the person that is sending that message. It can't be like a fake redirected location. When you send that email message, that commercial email, that subject line cannot be deceptive, right? It has to accurately reflect the content of the message. So if you're talking about like a new product, put that in the subject line. You also have to clearly identify within the body of the message that it's an advertisement. I mean, there's a lot of leeway in how you can communicate that it's an advertisement to disclose that information, but it has to be pretty clear to the reader that what they're reading is an advertisement from the business or a product that they're selling. Again, including in that message the location of where the business is, so a valid physical mailing address for the business. It can be, the actual address. It could be a post office. It could be, registered, an agent for the business. As long as it's one of the valid addresses for that business, it has to be included in the email. And then I think this is really important: how to opt out of receiving future emails from your business. If they've, they love all your products and they've just decided, you know what, I'm moving to Washington. I don't think I'm going to order from this Maryland farm anymore. I want to be off their listserv. And that's the only reason that anybody would ever stop ordering from your business, right? They're just moving out of state. You have to give them the opportunity to opt out of receiving your emails, your newsletters, your advertisements. I think a lot of times, if anybody who signed up for, to receive emails from business, you will open up that message and you can scroll right to the bottom, right? And that's usually where you see both the business, the address, the contact information, and unsubscribe. That's what it is, unsubscribe or opt out. And so they need to have that option clearly within the email message. And then if that, they decide to do that, then you actually have to honor that request promptly. So it has to be, you have to honor a recipient's opt-out request within 10 business days. That's what the law says. I know for a fact that I've unsubscribed to things and I still get emails from them more than 10 days later. So that might be tricky, especially if you kind of got like a schedule of messages set up to go out as part of your marketing and advertising strategy. But still something you have to keep in mind if you're going to be doing email marketing. And then even if you, for instance, have a company that manages all of your email marketing or advertising activities, and maybe they tell you that they're going to comply with this law, and you trust them, you still have to follow up with them, because ultimately the liability is going to lie with the business for the advertisement it's coming from. So, do your due diligence. And if you're working with a company, like an advertising company, and just keep an eye on what they're sending out, be on your own listserv so that you can know what language they're using and making sure it complies with the law. And so anybody who wants more details on the Can-Spam Act, again, can go to the FTC website. Very user-friendly, especially for folks who aren't like super tech savvy. I think, like maybe they're really basic, trying to learn about what it is. Very clearly written articles on this with some examples, facts. So definitely easy to get more information on this from FTC.
So moving on from that, if I have my jalapeno jelly and it's really good, everybody loves it, as you were saying, what stops someone else from marketing their disgusting jalapeno jelly as my jalapeno jelly?
Oh, that's really interesting. Yeah. So, as part of, I think when you get into like the whole online sales realm, it can be really tricky because everything is so easy to find, right? And there's just like a sea of information. How can you possibly keep track of all of it? And I think for farm businesses, it's like really important because, as they're building up an online business, an online presence, creating that brand, right? It takes a lot of work, I think, if you're going to make like the best jalapeno jelly, right? To like develop that recipe. And then as you create your products, creating that label. I think we all know that labels can be really eye-catching. And you put a lot of time and effort into thinking about how do you want your product to look and draw in customers, because we shop with our eyes just as much as our stomachs, I think. And so protecting all that work and that time. And, if you're creating your own artwork, even to create that label, how do you protect your interest in the artwork that you're creating to advertise your products? So that's a great question. I think with the recipes, it can be a little tricky. If it's going to be a trade secret recipe, if it really gets to that point, because I think the recipes overall are very similar overall, and you still have to like walk that line of like you're going to label your ingredients, right? So you can't exactly hide from the consumer what is in your jalapeno jelly or your product at all. You have to include that. You don't have to include like the exact measurements. That's your information. But if they're going to go and use your label, like that can be, whether it's your label artwork or your business name, there are protections, and those are called intellectual property protections for businesses. So those fall into two different categories generally. The first is copyright laws. And when we talk about copyright laws, we're really thinking about those sort of authorships. You are creating art or content. So we're talking about photos of your farm product, photos of your farm, or if you create artwork to put on your label, you've created that artwork, that's yours. If you write a really cool like little jingle about your jalapeno jelly, that song is protected, right, under copyright law. Or a poem, an ode to your jelly, like that's going to be copyright protected, right? You can publish it and you can say that this is mine, it's on my webpage. Or you can even register it with the U.S. Copyright Office, the U.S. Patent and Trade Office. If you're going to file a copyright with USPTO, there is going to be some fees with that. There are limits to how long those protections stay in place, unless you go and you do your renewals on a scheduled basis. So you have that information, and you say you've registered your copyright and you have it, it's yours. You've put everybody on notice. It's like it's on your webpage. You said this, I'm the author of this. Do not distribute or do not replicate at all. Like you can put that information on your webpage, right? Or if you share it on social media, you can still include that in your posts. Like, do not have permission to share it, and somebody does it anyway, because you heard it through a neighbor, right? Or maybe you found it online because you were doing your own due diligence. You're looking at your product to see if anybody else has anything that's significantly similar. If you find that out, you have that protection, and you can really you want to have information related to like when did you first publish that content? When did you publish it, which means make it public. So did you put it on your webpage? Did you share it on social media? Start using it in TV ads or print ads, something like that. So when did you start publishing it? And if that timeline shows that it was first, you could bring, usually you'd go to an attorney, tell them what's going on. They would probably send out a letter first, like a cease and desist letter for that other company to stop infringing on your rights to your jalapeno jelly like jams, and you see where it goes from there, right? But that would be an action that you could bring if there was a copyright violation. I think it's important to note for copyright things that yes, you can file it, but that doesn't mean the USPTO is out there doing searches for you. They're not going to alert you if another business has something like has stolen your artwork or stolen your jingle. Like they're not going to alert you to that. You have to go out and do your own research to catch those people. So that's copyright. If we're talking about trade name versus trademark, so maybe they're doing a jalapeno jelly too, and they've also decided to use a business name that is very similar to yours. So it's really easy to get them confused. That could also be a no-no, right? So trade name and trademark, I think, are two phrases that might be easily confused, but they do have different meanings. So a trade name is really the official name that's used to identify a business, within the stream of commerce, and it distinguishes itself from the business of other companies. So, Driscoll's and Dole and Purdue, like those main, like very large businesses, those are their trade names, right? It can be different from the legal business name. So what I mean by legal business name is that the name of the business that you have registered with the state of Maryland. I'm going with Maryland here because we are in Maryland. But if you're based in a different state, you would register your business name with the with that state department, right? That you register with. So that could be different. So you might be registered with the state of Maryland as McDonald's Farms, and then when you do business as like I don't know, what's a good one? Like McNugget Farm. It's different but similar. So keep that in mind. That trade name is something that you go through with the state. Even if you have no business entity, so you're going to need some sort of trade name at some point. So even if you haven't registered your business, you're a sole proprietorship, for instance, you are still going to need some sort of trade name to do business within the state so that you're not doing business as yourself, the individual. Anyway, point of this is, if they're violating the trade name so that you have your name, usually you can go in and do a search when you're registering your business and your trade name. You can do a search to see, are there existing businesses that have a similar name? And I think for the most part, people understand that you kind of want to avoid that, especially if it's going to be in an industry that is really closely related to what you are doing. So if a McNugget jelly is a food production is fine, but a McNugget like sewing business isn't going to be as confusing, right? Because one is selling sewn products, whereas the other one is selling food products. So, when you register your business, kind of keep that in mind. And again, like that's something that if you talk to an attorney and you realize that they're using your name and they're selling a product just like yours, and designing their label in a way to be really similar, then that could be a reason to go to an attorney and figure out how to make them stop. The last thing I want to talk about on this topic right now is trademark, just to distinguish it really from trade name. And because trademark is one of those things that a business will develop as part of its branding strategy, right? It's one of those things that help distinguish the business, especially from a visual perspective, like helps the consumer kind of associate that image with your business, and pair them up. And if you're around long enough and you have a quality enough product, it can really build that brand recognition and loyalty. So a trademark it can be an image, a symbol, it can also be words, and it can be paired together that are used, like I said, to identify your particular goods and distinguish them from those that are sold by another business or by another business generally. So, like I said, when businesses come up with their branding strategies, they put a lot of thought into creating their logo. That's what we usually refer to it as, your logo. That is something that your trademark is something that you can register both with the state or the U.S. Patent and Trade Office. And when you register a trademark, that in fact does guarantee exclusive use of that logo, that trademark, for your business. And it provides government protection from any liability or infringement issues that may arise. So, you register your trademark and you have that paperwork, whether state or federally. And again, say you have a competitor coming over with their jalapeno jelly and they've designed a logo or a trademark that looks very similar to yours. If you have your trademark registered, again, you have that protection for exclusive use. So you can go to your attorney and take action to make them stop using that. It might be a long process. It might not be a long process. It really depends, I think, on whether they want to assert that they were using it first, or they were first in the market with their jelly and their trademark, and that maybe you're infringing on them. So who knows what kind of battle it is. But having that record of like going back to the copyright, like when did you first publish? When did you first register your trade name? When did you first register your trademark? Having all of those things in a row, and like usually in these situations, sort of like the earlier one wins the day. So hopefully that answered your question.
Yeah, it's good to know that my jalapeno jelly is now well protected, and it seems that we are just about out of time. But would you like to remind everyone where they could go if they have any questions?
Yeah, absolutely. I know we covered a whole lot of information, especially during this podcast. So if anybody has questions about what we talked about today, or they want to check out one of those resources that I mentioned from ALEI's publication library, so the Legal Guide to Direct Farm Marketing, or the Regulatory Guide for Value-Added Food Production within Maryland, you can go to www.umaglaww.org, go to our publications library website or page, or direct marketing page, and you can find links to the resources there. You can also email me directly with any questions or follow up at MOTOD, like David, D like David, at law.u, Maryland spelled out, .edu.
All right. Thank you for your time, Ms. Todd, and everyone. Make sure to have a nice day, and we'll see you soon. We'd love to hear you soon on part 3.
Thank you.